This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So today's story started out with an interesting endeavor for me, trying to figure out how you pronounce this guy's name. I've never actually had to say it out loud. So is it Lil Nas? Is it Lil Nas? Is it Lil Nas-X, like something you squirt up your nose for congestion? No, fortunately, Wikipedia answers it for me here. It's Lil Nas-X. I was, of course, aware of his music, Old Town Road being one of the top songs of, I think, 2019. And he rose to popularity in both hip-hop and, I think, country categories. But recently he's been in the news for his new single, Montero, Call Me By Your Name, which has a religious theme to its music video. But that's really not what we're here to talk about. We're here to talk about this. In the process of doing his comprehensive release, which is something you do these days. You release the merchandise and you have the websites prepared and you have the music video and you have the thing. So it's one whole big package, and anybody who wants to see what you're doing can go look at your entire smorgasbord of media that you've prepared. Well, one of the things that he did was partner with this art conglomerate called MSCHF, and they like to make not necessarily controversial art, I guess, being new and attention-getting art could also mean that it's controversial. And since this one involves imagery of religious backgrounds, they did a shoe that has sort of satanic imagery of hell and Satan and all that, and there's the anarchist symbol or the pentagram or whatever. It's a black shoe, and they filled the air bladder with red liquid, which apparently contains 1 drop of human blood, which was donated by members of the artist group MSCHF. And so it has become extremely controversial in the public eye. There are some religious people who are upset with the imagery that's in his music video, and I've watched the music video and it seems pretty tame to me. Of music videos that I've seen and lyrics that I've read and heard, doesn't seem like a big deal to me, so I'm not sure what the big deal is there. Go watch it for yourself. I'm not going to show much of it here, if anything. But I thought, we could look quickly at the lyrics first and just see what that's all about, because in his lyrics here, he really doesn't say a whole lot more. The song seems to be about how he's got the hots for this person and, call me up and I'm going to come over, basically. And so if those lyrics are bad, but Old Town Road was not bad, you have to look a little closer, right? Because here he talks about how he's got lean all in my bladder, cheated on my baby. You can go and ask her. So this isn't great either. What the heck is lean in my bladder? I had to look that one up. That is Purple Drank, which apparently is a combination of Jolly Ranchers, Sprite, and cough syrup containing codeine. So an intoxicating substance that probably isn't really a very child-friendly thing to be singing about either. So I'm not sure why some people are upset about one and completely overlooked the other, except that it seems like people don't actually care about the lyrics or the music video. They just care about controversy. But speaking of controversy, what has been more relevant to our channel here is the controversy around the MSCHF Satan shoe, they're calling it. And Nike has now sued and won an injunction. So here is the Nike complaint for trademark infringement, false designation of origin, unfair competition, trademark dilution, and common law trademark, which is basically all of that, but using the state's common law trademark definition instead of the federal Lanham Act. They filed it in the Eastern District of New York, which is the Second Circuit Court of Appeals jurisdiction. So if this case got appealed, or if we're looking for precedent, we can look to the Second Circuit and the Supreme Court, of course. And then they filed for a temporary restraining order. A temporary restraining order is seeking any temporary order, 14 days usually, and of course a preliminary injunction, any order from the court doing something injunctive, so that it's not like a restraining order like, you know, in a domestic situation. It's the federal terminology for asking the court to do something, to order somebody to do or not do something. And then the court has granted the restraining order. So I thought today we could spend some time looking not at the rest of the controversy, but rather at what are the legal standards so we can understand what this trademark problem is. If you'll remember from our previous videos on trademarks, trademarks protect the branding and source of goods in commerce. It's not the same thing as copyright, which protects the expression of a concept, of a artistic or other concept in a tangible medium, like writing something down or recording a piece of music or something. Trademark protects the branding. So Nike obviously has protection for the word Nike and the swoosh and a whole bunch of other things. In fact, they're going to say so here in their complaint. And we're not going to go over this line by line like I sometimes do. We're going to go over this with various concepts. So let's take a look here. MSCHF is currently taking orders for shoes it refers to as Satan shoes, which are customized Nike Air Max 97 shoes that MSCHF has materially altered to prominently feature a satanic theme. You already can tell from this weird phrase, materially altered, that that's going to come up later. So keep that in your mind. Material alterations are going to be material to this claim. This was done without Nike's approval or authorization, and Nike is in no way connected with this project. Below is an image of the genuine Nike Air Max 97 shoe next to the customized Satan shoe. The material alterations include at least referring to the shoe as the Satan shoe, adding red ink and human blood to the midsole, adding red embroidered satanic themed detailing, adding a bronze pentagram to the laces, and adding a new sock liner. Nike has not and does not approve or authorize the customized shoes. Moreover, the company and its unauthorized shoes are likely to cause confusion and dilution and create an erroneous association between MSCHF's products and Nike. In fact, there is already evidence of significant confusion and dilution occurring in the marketplace, including calls to boycott Nike in response to the launch of the shoes, based on the mistaken belief that Nike has authorized or approved this product. Nike files this lawsuit to maintain control of its brand, to protect its intellectual property, and to clear the confusion and dilution in the marketplace by setting the record straight. Nike has not and does not approve or authorize the customized shoes. As an innovative brand that strives to push the envelope and do the right thing, Nike knows it may not please everyone all the time, but decisions about what products to put the swoosh on belong to Nike, not to third parties like MSCHF. Nike requests that the court immediately and permanently stop the plaintiff from fulfilling all orders for its unauthorized Satan shoes. So, a couple things going on there, though. Though they are correct that you cannot just go and make a pair of shoes and put the Nike swoosh on it and call them Nikes, there has to be some kind of balancing for when somebody buys a pair of Nikes and maybe colors in the swoosh. Let's say that you buy a pair of black Nikes with the white swoosh, and then you buy a marker and you color in the Nike swoosh to have a red swoosh instead. Are you really committing trademark infringement if you then go and resell that shoe? Maybe if you do it privately as a one-off, no problem. But what if you are making a commercial business out of it? Where is the line between buying a shoe and reselling it as a reseller and buying a shoe and making a material alteration and then selling it? Well, Why do we care about this material alteration? It's because this has to do with trademark first sale. The first sale doctrine is a legal concept that plays an important role in copyright law, limiting the rights of an intellectual property owner to control resale of products embodying its intellectual property. In trademark law, the same doctrine enables the reselling of trademarked products after the trademark holder puts the products on the market. The doctrine is referred to as the right of first sale, the first sale rule, or the first sale exhaustion rule. So wouldn't MSCHF have the right to buy a Nike product and then alter it and then sell it as an altered Nike product? Wouldn't that ameliorate or wouldn't that overcome Nike's objections? If you buy a Mercedes and then you take it to the shop and have a body kit put on it, or have the exhaust changed, or put a different supercharger on it, or painted a different color, aren't you making a material alteration? And then what if you went and took a Ford Mustang and turned it into a Shelby Cobra, Carroll Shelby? Wouldn't that be a material alteration, and wouldn't that be trademark infringement on Ford's trademark? So there's obviously something more going on here. Either these companies get permission to do this, they pay a license fee, or they do it under some exception to trademark laws. Now, trademark, again, protects branding. It protects against someone else using or altering your branding. It protects the source of goods. So the question is really going to be whether MSCHF used Nike's branding in such a way that created confusion about the source of the goods. Are they MSCHF's goods, or are they Nike's goods? And because they left the Nike swoosh on, there's going to be some confusion as to whether it's a Nike product. Again, looking at the image here, you see the Nike swoosh is still on the shoe. So there's going to be some question as to whether they are simply reselling, whether they are creating confusion, etc. So Nike claims to own the swoosh and the swoosh on footwear and the swoosh with the Nike word. And then they go into what MSCHF is doing. They claim that the MSCHF Twitter account posted about Nike Air Max 97 shoes branded as the MSCHF X Lil Nas X Satan shoes, contains 60 cc of ink and 1 drop of human blood, 666 pairs, $1,018, March 29th, 2021 is, I guess, when it goes on sale. So first thing that I want to react to is that doesn't say these are sold by Nike. It's saying that these are Nikes that we have altered. I'm not sure that that creates a misuse of Nike's trademark all by itself, but multiple media outlets reported on the shoes, etc. And of course, some people did get confused. Snopes.com did report that MSCHF buys the shoes from Nike, makes their own creative modifications before selling them, so that so far seems to be very clear that the alterations are not made by Nike, but rather they're made by the MSCHF people. And so there's a clearer picture of the shoe and what they've done with the insoles and the pentagram, and there's the back, and they actually look pretty cool. I like them. They also include Luke 10:18, which is a Bible verse, "I saw Satan fall like lightning from heaven." And the picture they're using is 6 of 666 pair of shoes that will apparently be sold as a limited edition. They describe the shoes. We don't really have to go into that. But then there's a bunch of posts, and I'm not even sure where these posts are from. Online consumer commentary that doesn't seem to be referenced as to where it's from, but people are saying, never buying a Nike shoe, crazy, we won't buy Nike again, you're banned, I'm appalled, never wear another Nike, throwing away all the ones I have now, Nike will no longer have anything to worry about me purchasing anything else from them, this is sickening. They couldn't put a scripture on other sneakers, but they can for this. This is disgusting. Nike should be canceled, etc., etc., etc. So Nike claims that MSCHF is deceiving consumers into believing that Nike manufactures or approves the shoes, and consumers believe that the shoes are genuine Nike products, causing consumers to never want to purchase Nike products again. They say that the customized Satan shoes are not genuine Nike products, Nike does not manufacture them or authorize them, etc. Unless stopped, the Satan shoes will continue to cause confusion in the marketplace. These acts are willful and deliberate, cause damage, and cause Nike to suffer irreparable injury, which is setting up the next part where Nike asks for an injunction, a temporary restraining order and preliminary injunction, which are the same thing, except that the restraining order is short-term and the preliminary injunction is for the duration of the lawsuit. And then a permanent injunction would be ordered at the end of the lawsuit after an adjudication. We don't need to go over every line of this either, because they're going to say most of the same things. They're going to say that the shoes are unauthorized, that they are trademark infringement, that people are upset. Here are some better examples of people being upset with Nike. Nike goes into the factual background, which is basically what we've discussed. They own a very, very famous, probably one of the most famous trademarks in the world. The Nike word and the Nike swoosh are pretty much known to everybody. Can't really imagine that anybody has any dispute over that. And it's certainly too late. Once you've reached a sufficiently famous mark status, you can no longer challenge somebody's trademark. And so no one has challenged Nike's trademark. Therefore, it's permanent at this point. As long as Nike continues to use it, there's no challenging the trademark. So we're not even worried about that. But Nike is very concerned about its reputation and goodwill, and claims that MSCHF attempted to capitalize on the strength and fame of Nike by using its footwear to promote, advertise, market, offer to sell, and sell products bearing the marks. That because the Nike swoosh is on this Satan shoe, that is an unauthorized use of Nike's mark. It'd be one thing if Nike does not have a trademark on the shoe itself, but this shoe still contains the Nike swoosh. MSCHF took orders for 666 pairs. They priced them at $1,018 a pair. I'm not sure the significance of the amount of money. Certainly they didn't sell them for $666, so I guess they're trying to find a market clearing price. Not sure there. It does have all the things that Nike says it does that I'm going to stop repeating at this point because YouTube is going to hate me at some point. And then they go into the preliminary injunction standard. The plaintiff must establish the likelihood of an irreparable injury in the absence of an injunction, a likelihood of success on the merits, or sufficiently serious questions to make a fair ground for litigation. Plus, the balance of the hardships, which party is going to suffer the most, tips decidedly in one party's favor. And of course, since Nike's asking for the preliminary injunction, that tips in favor of Nike. Have to have an irreparable injury as well. So Nike claims that it is likely to succeed on its trademark infringement claims. It has a mark. Obviously, we're not going to dispute that it has a mark. There is obviously some kind of confusion. Does it reach a level of confusion that we would consider it to be a trademark infringement? That's going to be based on the strength of the mark, the degree of the similarity, the proximity of the products, the likelihood that the prior owner will bridge the gap, that it will cause actual confusion, the junior user's good faith in adopting its own mark, the quality of the defendant's product, and sophistication of buyers. This is all kind of weird, though. How does that really apply when someone takes a product they bought and then modify it, and they sell it as a modified product? There's actually a different standard that applies. It would be either that first sale exception that we talked about, or it would be the fair use exception. So what I wanted to do today, all of this was sort of building up to this moment. I want to look at that first sale exception in trademark and see, because Nike's not going to tell you, Nike's not going to put in their complaint that there's a first sale exception that applies, and maybe MSCHF has some kind of defense. So since we don't have a defense yet, an answer or otherwise a motion to dismiss or some kind of defense, what we need to do is look at case law. And there's remarkably little case law on this issue. It is a fairly novel issue that may have been adjudicated at the Trademark Trial and Appeals Board level, but not really at the district court level and not really at the appeals court level. I found only 2 major cases on the actual issue of trademark first sale and material alteration. And so the first one that I want to look at here is called Brilliance Audio versus Hates Cross Communication. And we're not going to read through the whole thing, but I'm going to give you a little bit of background. Brilliance Audio appeals from the district court's dismissal of its claims for copyright and trademark infringement. The case presents a question that has not been considered by this court or any other: whether the record rental exception to the copyright first sale doctrine applies to all sound recordings or only music. Specifically, this case asks whether the exception applies to sound recordings of literary works. We find that it does not, and thus the district court did not err in dismissing their case. We disagree, however, with the district court's dismissal of Brilliant's claims for trademark infringement. Following the law in our sister circuits, we conclude that 2 exceptions exist to the first sale doctrine under trademark law, and that Brilliance's complaint, construed broadly, has alleged that these exceptions apply in the present case. We thus affirm the decision of the district court with respect to the copyright claims, but we reverse in respect to the trademark claims. So real quick, we're here on the motion to dismiss standard, which means we're at the very beginning of the case, and the court dismissed the case. So this isn't an adjudication of whether Brilliance's claims got adjudicated one way or the other. It's that they shouldn't be dismissed and Brilliance should be allowed to put on its case. Rather than going over the entire case, we're just going to do a search for trademark. It is true that trademark law contains a first sale exception that provides a defense to claims of infringement. Under the exception, resale by the first purchaser of the original trademarked item is generally neither trademark infringement nor unfair competition. So at first, that sounds like you can buy Nike shoes and you can resell Nike shoes. So what did MSCHF do wrong? The rationale for the first sale rule is that trademark law is designed to prevent sellers from confusing or deceiving consumers about the origin or make of a product, which confusion ordinarily does not exist when a genuine article bearing a true mark is sold. However, there are 2 situations in which resale of a product does not fall under the first sale exception. The first situation is when the notice that the item has been repackaged is inadequate. See Enesco versus Costco. The Ninth Circuit in Enesco looked to the Supreme Court's language in Cody in finding a requirement of adequate notice. In Cody, the question was whether the defendant's repackaging of plaintiff's perfume and powder into smaller containers, which it then sold, constituted an infringement of the plaintiff's trademark. In finding that it was not, the court stated, "A trademark only gives the right to prohibit the use of it so far as to protect the owner's goodwill against the sale of another's product as his. When the mark is used in a way that does not deceive the public, we see no such sanctity in the word as to prevent its being used to tell the truth. It is not taboo." So at first, that sounds like as long as you say, we altered Nike Air Max 97 shoes and then sold them as our own, that sounds like it would fall under that fair use or first sale exception. If the defendant's rebottling of the plaintiff's perfume deteriorates it and the public is adequately informed about who does the bottling, the public, with or without plaintiff's assistance, is likely to find out, and so of the powder in its new form. We find this reasoning persuasive when the public has adequate notice that the purchaser has repackaged the trademarked item, then the dangers of consumer confusion and trademark delusion are minimized. Absent this notice, the trademark holder risks being associated with a product that is not of the same quality as the original trademarked item. In order to properly protect trademark rights, this limit to the first sale doctrine is necessary. So that argument is going to turn on whether the public was adequately notified that MSCHF is selling modified Nike Air Max 97 shoes. But that's not all. The second situation in which the first sale doctrine does not apply is when an alleged infringer sells trademarked goods that are materially different than those sold by the trademark owner. We join the many circuits that have adopted a similar rule. And then they go into 1, 2, 3, 4 cases that say this, cases that apparently did not show up in my research. But, now we would look into them. If we were doing in-depth research and found them, we would now read all of these cases. Like the requirement of adequate notice, the rationale behind the exception is that a material difference in a product is likely to cause consumer confusion and dilute the value of the trademark. We note, though, not all differences are material. To be material, a difference must be one that consumers consider relevant to a decision about whether to purchase a product. Because a myriad of considerations may influence consumer preferences, the threshold of materiality must be kept low to include even subtle differences between products. The question of materiality is a fact-based inquiry requiring examination of the products and the markets at issue. C, the Davidoff case, looking to the testimony of industry experts and findings that physical alterations of the goods container degraded the appearance of the product in finding a material alteration. C, Nestle, noting that materiality must be determined on a case-by-case basis. Thus, an allegation of a material difference cannot be properly dismissed on motion to dismiss grounds. So in the Brilliance case, then, the case was remanded for further proceedings. So that tells me that there's at least some question that should be adjudicated by a fact finder, or after some discovery, or after the parties have had a chance to make their arguments, that says whether the alteration of the Nike Air Max shoes and whatever notice there was from MSCHF that they were altered, whether that makes this materiality or first sale standard. Neither of those explanations really address directly what if an artist buys a product and then alters it in an artistic way and then resells it, telling everyone that they altered it. So I think there's going to be some either new case law here, or the court's going to have to interpret the existing case law in a new way. Whether it becomes precedential or not sure, but there's going to be some kind of novel exploration of law here. But continuing, there are other cases that talk about this. Here's one from the District of Nevada, Stevo Design versus SBR Marketing. Defendant SBR encourages users to frequent its website and accumulate loyalty points. The plaintiff's claims allege that SBR and its users have published Stevo's works on SBR's website to obtain those loyalty points without having obtained a license. Defendant is alleged to have purchased sports analysis from Stevo and to have unlawfully posted this analysis on SBR's message board. Plaintiffs have alleged trademark infringement, false designation of origin, etc. Under the first sale rule, the right of a producer to control distribution of its trademarked product does not extend beyond the first sale of the product. A reseller of branded goods who does not materially change the goods is not a trademark infringer. The rationale for the rule is that trademark law is designed to prevent sellers from confusing or deceiving consumers. So again, I think the situation is going to turn on whether MSCHF had deceived consumers into thinking that this was an authorized Nike product, or if it was an altered Nike product. If they say this is an altered Nike product, I think that's going to be a harder case for Nike to make. But it's also still possible that a court would consider that the Nike swoosh was still on there and it wouldn't be abundantly clear based on those tweets and website and pictures alone that it's an altered Nike product, or rather that it's MSCHF's alterations of a base Nike product. So in the Stevo case, the infringing activity allegedly was people buying reports from Stevo and then posting them on SBR's message board. Plaintiffs say this creates initial interest confusion as to the legitimate source of the reports. The court says that the first sale exception requires more than this. The reseller in Bandag versus Al Bolser's tire stores used the producer's mark in a phone book ad to suggest that the reseller was an authorized franchisee. The court found that this conduct created the false impression that the reseller was an authorized dealer. In Bernina of America versus Fashion Fabrics, the court concluded that the reseller misrepresented itself as an authorized dealer. On the other hand, when a website included comments critical of the mark owner, the court found confusion as to the authorization or the sponsorship incredible. Here, the complaint cannot be read to allege that SBR used Steve-O's marks in any ads or that SBR held itself out as knowledgeable as to Steve-O's workings. Plaintiff's complaint identifies comments critical of Steve-O's analysts on the message board. So they're saying that there was not enough material alteration there, and it was clear to consumers who was the source of the goods. In short, plaintiffs have alleged nothing to show that SBR created the type of confusion needed to defeat the application of the first sale doctrine. So there is some kind of line there. Then the next exception or defense that might apply to MSCHF's use would be the fair use doctrine, which in trademark is completely different than copyright. We're not going to be talking about transformation. We're not going to be talking about market usurpation in the same sense, at least. We're not going to be talking about how much was used versus what's fair to use. And we're not going to be talking about commerciality versus non-commerciality or published versus unpublished. That's all copyright. This is completely different. So clean your head of any copyright fair use doctrine. This is the nominative fair use doctrine. The doctrine divides trademark use from trademark mention. To use a mark as a mark, the defendant must attempt to identify the source of the mark with the defendant. So MSCHF would have to identify itself as an authorized Nike reseller, or otherwise say that they are selling Nike shoes unaltered, pretty much, or not say that they are altered. So this contrasts trademark use with use in commerce. Trademark mention, on the other hand, is any other use of the mark to refer to a particular product for purposes of comparison, criticism, point of reference, or any other purpose. In a terminological infelicity common to this area of law, there's a phrase you never thought you'd hear, terminological infelicity. Nominative fair use denotes trademark mention. The Ninth Circuit identified 3 factors in attempting to carve out trademark mention from trademark use. First, the product or service in question must not be readily identifiable without the trademark. So, shoes, can you say we've modified shoes, or do you have to say we modified Nike shoes? Second, the mark may only be used to identify the product or service. And third, the mark user must do nothing to imply sponsorship or endorsement by the trademark holder. See New Kids on the Block, which we're going to take a look at in a moment. So if MSCHF used the mark only to identify the product or service, and they did nothing to imply sponsorship or endorsement, it sounds like that might be a successful argument under fair use. Nominative fair use names a use of the mark that is not likely to confuse. If the pleadings fail to allege a mark's use beyond nominative fair use, then the plaintiff has failed to allege likelihood of confusion. So that would be some kind of defense. And then the court goes on to resolve the Steve-O versus SBR case, saying that the marks at issue are proper names of the analysts. It would be difficult to identify Steve-O's sports analysis services without using these marks. So could you identify MSCHF's use of Nike's shoes without saying, these are Nike shoes, and then we're altering them? It's really going to turn on how clear it was to consumers, and the people who are reacting on social media saying that they're never going to buy Nike again, sure, that's Nike's argument, but then there's also going to be a whole argument from MSCHF saying, look at how clear we made it. Everybody knew that we had modified Nike shoes. Look at the MSCHF brand. That's what we do. They had previously altered Nike shoes, calling them Jesus shoes, and they looked like this, and it looks like they have a cross on them here. Here's a better picture, and that's some kind of not trademark infringement according to Nike, who didn't sue over that. And in trademark, you're supposed to enforce your trademarks, so if that was infringement, Nike should have sued over that. Of course, there's something in Nike's complaint here that sort of leaves the door open for that. They say, Nike is aware of another product previously sold by MSCHF under the name Jesus Shoes that also infringes upon Nike's intellectual property rights. While Nike reserves the right to amend its complaint to add allegations of infringement against the sale of the Jesus Shoes, these sneakers are not at issue in this motion because MSCHF is not currently selling those shoes. So there's still some possibility that Nike will come after MSCHF, at least for the infringement, but they can't come after them for an injunction because Nike is not currently suffering an irreparable injury. And then there's the New Kids on the Block case. The individual plaintiffs perform professionally as the New Kids on the Block. No longer are entertainers limited to their craft in marketing themselves to the public. This is the age of multimedia publicity blitzkrieg. Trading on their popularity, many entertainers hawk posters, t-shirts, badges, coffee mugs, and the like. The New Kids are no exception. The defendants are two newspapers of national circulation conducting several polls of their readers seeking to answer a pressing question: which one of the New Kids is the most popular? Fearing that the two newspapers were undermining their hegemony over their fans, the New Kids filed a shotgun complaint in federal court, raising no fewer than 10 claims, basically common law trademark and false advertising and other trademark infringement and unfair competition claims. And the court goes on the fair use issue, saying that a problem arises when a trademark describes a person, place, or an attribute of a product. If the trademark holder were allowed exclusive rights to such use, the language would be depleted in much the same way as if generic words were protectable. Thus, trademark law recognizes a defense where the mark is used only to describe the goods or services of a party or their geographic origin. The fair use defense, in essence, forbids a trademark registrant to appropriate a descriptive term for his exclusive use and so prevent others from accurately describing a characteristic of their goods. In other words, MSCHF's defense would be, we are describing our shoe as we took a Air Max Nike 97 shoe and we altered it to make it all those things, and then we sold it as an MSCHF artistic product. Once again, the courts will hold as a matter of law that the original producer does not sponsor or endorse another product that uses his mark in a descriptive manner. With many well-known trademarks such as Jell-O, Scotch Tape, and Kleenex, there are equally informative non-trademark words describing the product: gelatin, cellophane tape, facial tissue. But sometimes there is no descriptive substitute, and a problem closely related to genericity or genericness and descriptiveness is presented when many goods and services are effectively identifiable only by their trademarks. For example, one might refer to the two-time world champions or the professional basketball team from Chicago, but it is far simpler and more likely to be understood to refer to the Chicago Bulls. In such cases, use of the trademark does not imply sponsorship or endorsement of the product because the mark is used only to describe the thing rather than to identify its source. Indeed, it is virtually impossible to refer to a particular product for purposes of comparison, criticism, point of reference, or any other such purpose without using the mark. For example, reference to a large automobile manufacturer based in Michigan would not differentiate among the big three. Reference to a large Japanese manufacturer of home electronics would narrow the field to a dozen or more companies. Much useful social and commercial discourse would be all but impossible if speakers were under threat of an infringement lawsuit every time they made reference to a person, company, or product by using its trademark. A good example of this is Volkswagenwerk versus Church, where we held in the Ninth Circuit that Volkswagen could not prevent an automobile repair shop from using its mark. We recognize that in advertising the repair of Volkswagens, it would be difficult, if not impossible, for Church to avoid altogether the use of the word Volkswagen or its abbreviation VW, which are the normal terms which to the public at large signify appellant's cars. Church did not suggest to its customers that he was part of the Volkswagen organization or that his repair shop was sponsored or authorized by VW. He merely used the words Volkswagen and VW to convey information about the types of cars he repaired. Therefore, his use of the Volkswagen trademark was not an infringing use. And the court's going to go on and on and on, of course, and we need to stop at some point. But that's what MSCHF's defense is going to be, that they are making a first sale or a fair use of Nike's trademark by taking a product that Nike already makes and incorporating it into a product that MSCHF makes. If I buy a gear from a gear manufacturer and I make a machine out of that gear, the manufacturer of the gear does not get to say, well, we had our trademark stamped on the gear, therefore you're misappropriating our use by selling it as part of a larger machine. You have to do more. You have to say, this machine was made by that gear manufacturer, and therefore you should buy our machine because we're an authorized machine builder out of that gear. If you did that, okay, that's infringement, assuming that you're not authorized. And so the MSCHF situation is somewhere in between. They did use a Nike product to make their product, and they did say their product was made out of a Nike product, but how clearly did they say that? Did they cross the line into making people, reasonable people who were actual consumers in the market, did they actually confuse them into thinking that MSCHF is making an authorized Nike product, or did they make it clear enough that anybody who did even the littlest bit of research would see that the product was not an authorized Nike product? So nevertheless, turning back to the Nike preliminary injunction motion, the court did grant the motion for the preliminary injunction telling MSCHF not to sell any more of the shoes. Nike moved for a temporary restraining order for a preliminary injunction. The court reviewed plaintiff's complaint, the memorandum in law of plaintiff's motion for a temporary restraining order, the supporting evidence. Note that something the court did not do is hear MSCHF's defense. That's not necessary in an ex parte restraining order. The court grants the motion for a temporary restraining order pending resolution of the motion for a preliminary injunction. The preliminary injunction motion is where the defendant will get a much bigger chance to defend themselves. Based on the limited record, so the court knows that it's only got one half of the story, the judge concludes that Nike is the owner of the mark, that MSCHF took 666 orders for shoes, that the shoes contain the swoosh design, and the trademark and logo appear on the MSCHF website. Nike has not given approval. Nike has shown a likelihood of success on the merits of some of its claims. It has carried the burden at this stage, only this stage, the motion for a temporary restraining order, of showing that MSCHF's actions are likely to are confusing consumers about the origin, sponsorship, or approval of MSCHF's goods. Nike has also demonstrated that the MSCHF's actions are likely to dilute and tarnish their marks. Nike has also demonstrated a likelihood of irreparable harm absent a temporary restraining order. Defendant has not rebutted the presumption of irreparable harm on the record before the court at this time. And I find the issuance of the requested restraining order is in the public interest, that the harm to Nike in denying this motion outweighs the harm to MSCHF in granting it. Thus, on this limited record, the court keeps saying on this limited record for a reason. The court does not have all the information yet. It knows that, and it's saying that over and over and over again. I find a temporary restraining order is necessary pending resolution of the preliminary injunction motion. Defendant has asserted a First Amendment defense based on the purported expression embodied by defendant's production and sale of its shoes. First Amendment rights of artistic expression are paramount, and defendant will have a full opportunity to pursue this affirmative defense at the preliminary injunction stage. The burden of proof lies with defendant on affirmative defenses, as counsel for MSCHF acknowledged at oral argument. As of now, based on the limited record, defendant has not carried the burden. It is therefore ordered that pending the hearing and determination of plaintiff's application for preliminary injunction, defendant and everyone it's involved with are hereby enjoined from fulfilling any orders for the shoes, for using the Nike word mark in a confusingly similar way, referring to or using any prohibited marks in its advertising, promotion, or marketing, or instructing, assisting, aiding, or abetting any other person in engaging or performing any of the activities, etc. So they can't get around it by going through a different entity. This was ordered on April 1st, which was Thursday, so if MSCHF shipped 665 pair of the Satan shoes before this order was entered, then it doesn't have anything to do with this order. It's not in violation of this order. It may still be trademark infringement, and it may still owe trademark infringement damages, but once the shoes were shipped, as long as they were shipped before this order was entered, then they should be in the clear. And for some reason, they are withholding the 666th pair of shoes, which I think was something they were doing on purpose, not something that was barred by this order. And I guess they're going to hold those, and if they lose the case, then they can't ship them. But if they win the case, that's probably going to be a pretty darn valuable pair of shoes. So then the court sets a date, April 14th at 3 p.m., the defendant must show cause why a preliminary injunction should not be issued. Nike has to put up a $50,000 bond by April 12th, and defendant shall file opposing papers by April 8th. Plaintiff shall reply, Nike shall reply by April 12th, and the court will post information on how to access the preliminary injunction hearing on the public docket. And that is Eric Comite, United States District Judge for the Eastern District of New York. I'm not sure why Nike went for the Eastern District of New York. I'm assuming it's because the MSCHF Product Studio Inc. is located there. And that would be the best place for Nike to do that, since they can really go anywhere. It's easier for them to sue where there's not going to be any jurisdictional issues. So that's really interesting situation. MSCHF then issued a statement. They said, MSCHF is a conceptual art collective known for interventions that engage fashion, art, tech, and capitalism in various, often unexpected mediums. We believe it is better to make art that participates directly in its subject matter. It is stronger to do a thing than to talk about a thing. MSCHF makes artworks that live directly in the systems they critique, instead of hiding inside white-walled galleries. There is no better way to start a conversation about consumer culture than by participating in consumer culture. We choose a specific medium to engage with a specific subject matter. We will make shoes, stream video, publish books, make paintings and sculpture, build apps or web services. Everything is in service to the concept. MSCHF is fully context chameleonic. That's a great word that I have never heard before. Chameleon turned into chameleonic. Over a year ago, we released the Jesus Shoes. As a manifested speculative artwork, Jesus Shoes conflates celebrity collab culture and brand worship with religious worship into a limited edition line of art objects. Last week's release of the Satan Shoes, in collaboration with Lil Nas X, was no different. Satan Shoes started a conversation while also living natively in its space. It is art created for people to observe, speculate on, purchase, and own. Heresy only exists in relation to doctrine. Who is Nike to censor one but not the other? Satan is as much a part of the art historical canon as Jesus, from Renaissance hellmouths to Milton. Satan exists as the challenger to the ultimate authority. We were delighted to work with Lil Nas X on Satan's shoes and continue this dialogue. We are not affiliated with Nike, as we have consistently iterated to the press. We were honestly surprised by the action Nike has taken, and immediately after Nike's counsel sent us notice, we reached out, but received no response. MSCHF strongly believes in the freedom of expression, and nothing is more important than our ability and the ability of other artists like us to continue with our work over the coming years. We look forward to working with Nike and the court to resolve this case in the most expeditious manner. Given the current circumstances, this action by Nike will also prohibit Lil Nas X's Twitter giveaway for Satan's Shoes edition 666 from happening indefinitely. We appreciate everyone's patience and continued support during this process. So if I was to read into that a little bit, it sounds like they're citing the fair use doctrine, the First Amendment concepts of artistic expression, probably first sale in there as well, saying that they did not confuse consumers because they consistently told consumers and the press that they are not affiliated with Nike and that they are making their artwork out of the Nike shoes. It sounds like a compelling defense to me, and my personal bias is that this is a fair use, this is a first sale, not a material alteration in the same sense as if I was saying I'm selling Nike shoes, but I'm making a material alteration to them without telling people that I was making a material alteration. They told everybody they're selling shoes that have been altered. That to me says that the consumers who are in the market to buy those Nike shoes should know that they aren't genuine Nike authorized shoes that have not been altered. Then, of course, referring to Nikes by saying these are Nike shoes would be a nominative fair use or fair use mention or trademark mention. And then, of course, concepts of First Amendment expression. The courts are forbidden from infringing on the First Amendment. I don't know what the argument is there. I didn't research that for this story, but the idea would be that their artistic expression trumps any enforcement that the courts can make of Nike's trademark. As long as there's no intentional confusion in the marketplace, trying to pass off MSCHF's shoes as being authorized Nike shoes. So they will have a chance to make their argument both for the preliminary injunction and for any final adjudication by the court after probably a long period of discovery and back and forth on either summary judgment or some kind of actual trial on the merits. So we won't have resolution to that for a while, but we will have some kind of preliminary injunction motion hearing at some point, and we will get to hear both sides' arguments. I might even be able to attend the hearing itself and take notes, because the court doesn't allow us to record those yet. I will post more information about that on our Discord. Why didn't they do the legal thing and get a license? Would Nike give a license to criticize Nike? That's the one of the bases for fair use in copyright, is that you wouldn't expect a copyright owner to license a mark for criticism. Would a product owner send free product to a product reviewer knowing that the product reviewer is going to make a critical review as opposed to a favorable review? So if I own a product, let's say I own one of these vaporware Kickstarter things, like a solar powered water bottle or something like that, doesn't make nearly enough energy generation to purify water or whatever. So I want to make everybody think this is a wonderful new technology. So I only send it to people I know are going to give a favorable review. Well, what if somebody obtains the water bottle and wants to make a critical review? Can I eliminate their critical review by saying, well, your review was not authorized. I didn't authorize you to show a picture of my water bottle. That's copyright infringement. I didn't authorize you to say my name as a water bottle manufacturer, because that's trademark infringement. So the law carves out these exceptions, especially for criticism, because a copyright owner or a trademark owner would usually not give permission in the form of an authorization or license to someone who's going to give them a negative review. It would be a different scenario if Nike required every purchaser to agree to a terms of service. However, there's still such a thing as an unconscionable term or an unconscionable terms of service. And a court might agree that requiring someone to agree that they won't alter the product that they're buying using a terms of service, the court might say that that's unconscionable. The Ferrari situation, which was an interesting one, where Deadmau5 had purchased a Ferrari and Ferrari makes you sign an agreement giving them the right of first refusal if you decide to either alter or sell your car. And so I believe he had to remove the wrap and not alter a Ferrari because he agreed to do that. I'm not sure he challenged that in court. I'm not sure. Maybe he didn't want to challenge it, or maybe it wasn't challengeable. Maybe he talked to lawyers and they all said this is not worth it. So I'm not sure how that situation resolved. Yeah, it seems like the Ferrari situation was never actually taken to court. So it's hard for me to say how the courts would have resolved that one. It may have been because it would involve EU law, since any agreement with Ferrari, I think, would have been under EU law. I'm not sure. What do you think of this situation? Was MSCHF's use a authorized use in the sense that it's authorized by fair use or first sale or First Amendment? Or was it an unauthorized trademark infringement of Nike's marks, their brand as Nike, the swoosh because it's on the shoe, and MSCHF didn't do enough to eliminate confusion in the marketplace? Maybe by removing the Nike swoosh from the shoe, maybe by not saying these are Nike shoes that we have altered. What do you think? Let us know in the comments below. Let's have a great discussion of this matter. So that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv at Sunday mornings at 10 a.m. Eastern Time. This is a community-supported legal education channel, meaning we need your financial support on a monthly basis on patreon.com/ljfrench, on sponsors.com/law, or through YouTube membership or Floatplane membership. Thank you very much in April of 2021 to our $50 plus supporters: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn, Abel, Sovereign Tittizen, ShadowTycho, RDHDragon, and Earthbound Star. And thank you very much to the $5 plus supporters. Everyone's been scrolling on the updated LED panel behind me and will be on the videos in front of me that drop. I love you all. Have a great week. I hope you all had a nice holiday weekend, and I will see you in the videos. Bye.
I'm not a cat.